Mr. Trush, are you able to hear me okay?
Yes, Your Honor, I can.
Okay, we'll go on the record in People versus Mallory Stefan. This is file number 255348. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Miss Stefan. And I don't see her, at least in my view from the camera.
She is not present here in the courtroom today.
Well, Your Honor, I spoke to her just yesterday afternoon. She had indicated to me that she had secured a ride through a friend to be up there.
I'm gonna ask the court officer to check in the lobby. Wants the podium here, please. All right, Mr. Trush, we do have Ms. Stefan present here in the courtroom today. This is scheduled for jury trial set to begin on Monday, I believe, April 14th. How does the defense want to proceed today?
Thank you, Your Honor. As I'd indicated, I had a chance to speak to Miss Stefan yesterday. When we had talked, we went over what the offer is. The offer in this file contemplates 2 misdemeanors. That is an attempt of count 2 in a domestic violence second. At the end of our discussion, I think Miss Stefan was still leaning towards a trial. Is that accurate, Mallory? Do you still want to proceed to trial?
Yes.
Okay. All right, so we'll proceed as scheduled. Ms. Koch, I know you made a request to review the jury questionnaire, so I'll sign that request and provide that to you.
Your Honor, this case is stacked with another case for Monday. The next case, they're very close in time, involves a 7-year-old who was sexually assaulted. And it's gonna be it's really hard to deal with a 7-year-old. She's been to the courthouse, she's prepared with her counselors, she's come in and seen where she's gonna sit. And because it's very eyewitness based, I would ask that case, if it is going to trial, which we're going to know in about 5 minutes, I would ask that case go over this case and that we have this one go second, just because of the nature of the criminal sexual conduct in the 7-year-old.
All right, Mr. Germerty, does your client intend to proceed to trial?
He's not here yet, Judge. I just spoke to him. They're coming from Gaylord, I think, with the storm. They were running a little late. My last conversation with him was they were going to proceed to trial, but I wanted to have another conversation with my client here this morning and confirm that was the intent. So
Okay.
without him here, I don't want to represent something I'm not sure of here, Judge.
All right. I think what I'm going to do, Mr. Trush, is I'm going to have you and your client just wait a little bit here. I'd like to find out if Mr. Wells' case is gonna go to trial. I agree with Ms. Koch based on what she's saying, that that case should have precedence. But I don't want to tell you and Ms. Stefan that we're not gonna have a trial in your case. I'm not sure that Mr. Wells' case is gonna go, so I want us to get that on the record first, okay?
And Your Honor, I have no objection to that. I do want the court to be aware. I have hearings in front of Judge Hunter here in Otsego, basically starting at 9:15 through essentially the end of the morning. So however the court
Okay.
wants to proceed, I will.
I'll try to look for a break, and I'll coordinate that with Judge Hunter's, assistant, Chris. And try to coordinate that with the time that you're on a break there, you have availability.
Certainly. Thank you, Your Honor.
Okay, so Ms. Stefan, I'm just gonna ask that you remain here in the courthouse for a few minutes, okay?
Okay.
And we'll take a short recess. Mr. Grimmerty, if you could just let the court officer know or clerk know. Once you get a chance to speak with Mr. Wells. Bring Mr. Clum Lodge, I'm assuming. he's live.
I'm Doc's not here yet.
Okay, they're bringing him.
That's correct, but they're not here yet,
Okay.
right?
All right, so we'll take a short recess. We'll be back on the record in a few minutes.
I got a couple extensions in the discharge. I mean, I can take care of them later unless,
Nope,
but no.
I will take care of them.
Teacher same, so
Wait,
like Rotan, if you could just mail that to him,
sure.
and Buckton too, I guess both of them.
Okay, I will do
And
that.
I take care of Shalaf.
All right,
I gotta go see her dad anyway, so.
okay.
Okay.
Thank you.
I know that your sound was on. I don't know, where's it?
Oh. You're off mute.
Okay, we're on the record in People versus Logan Gerald Clum, case number 255388. The record should reflect the defendants present here in the courtroom today. If I can have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, I'm ready for everything. Yeah, Mr. Clum.
Thank you. This is the date and time set for sentencing in this matter. Mr. Clum, have you had a chance to go through the pre-sentence report with Mr. Gurmurthy about that?
Yes, I have.
Mr. Gurmurthy, are there any additions, deletions, or corrections that need to be made to that report?
To the report, no, Judge.
Are there any challenges to the scoring of the guidelines?
No, Judge.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court?
Yes, Your Honor.
Mr. Clum, if you and your attorney can be seated at council table there. Ms. Coe, as a Ms. Gray that would like to address the court.
Yes.
She's present here.
Rachel's looking. Mind if I move this?
Yeah.
Whatever you need to do. Ms. Gray, you're Stephanie Gray, is that correct?
Yes.
What is it?
During the time that Logan has been under no contact order with me, he stalked me, instilling fear in me every time I left the house, going to work, meeting friends, going to the doctor's appointments. Sometimes he had our children with him, and they would see him watching my location on his phone. He would tell me where I had been and who with. I was living in fear every day, not knowing where he might turn up. I felt terrorized, and any sense of freedom I had was taken away from me. Once I discovered there had been a tracking device on my car, I understood how he knew everywhere I'd been, and I feel violated and terrified still. We have a custody agreement allowing him to call 2 calls per day to our children. During his incarceration, he's used these calls to badger the kids about me. He asks where I'm at, if I left, who I left with, what I look like, did I fix my hair? Am I on a date? He has questioned them so many times and argued with them so much that they don't want to talk to him much anymore. The only kid that still wants to talk to him is our youngest, and she's only 8 years old and doesn't really understand a lot of what has happened. He questions her about me. He's told her more than once that if I'm seeing a certain man when he gets out, he's gonna make sure he runs away. I went out with friends one night, and the next day he told my youngest daughter to tell me he hoped I had fun at the bar the night before. No one knew I was going. I felt like he's still watching me all the time. He makes sure I know that he knows what I'm doing, even though he's incarcerated and he knows my every move. He writes letters to me and tells me that I'll always be his wife, and he calls me his queen. He was married to a woman while he was incarcerated and still is saying these things to me. I don't feel like he will ever stop watching my every move or ever let me have a real life. I'm in therapy and prescribed medication and struggle with anxiety and trauma issues daily. The first thought I got when I was told he again was getting a plea deal is that I'll have to quit my job. I have to drive 25 miles to get to work, and I'm afraid that he'll stalk me on the remote drive. I'm afraid for my safety. My oldest daughter is seeing a therapist and has to take medications to help her with depression and sleep problems because that were caused by his behavior. She's terrified of him. My son is like a new person since Logan has been gone. Shane was so angry and lashing out by breaking things. He has been in counseling for the past year. He never has an outburst anymore. He doesn't want to speak to Logan or see him. He refuses to talk to him on the phone. My daughter's even started out speaking to him on the phone calls, but she doesn't want to talk to him anymore either. The nonstop questioning about me and arguing with them over the past year has made her so angry with him. She doesn't want to talk to him. She's afraid of him getting out and having to spend time with him alone. My youngest daughter has stomach aches and gets stressed from the questioning about me on the phone calls. The calls turn into arguments often, with them telling him he doesn't need to know about me and what I'm doing. We are currently living with my parents. Logan's calling and arguing with me and the kids numerous times daily over the past year has caused my parents, my kids, and myself so much stress. It has been a constant, all day, everyday source of anxiety for everyone. He's very manipulative and controlling. It has been like he's with us more now than ever before. He was able to get someone to keep money on his account to make as many calls as he wanted. He has called as many as 60 times in a day. I have proof of these calls if you need to see them. I've had to block him on my cell phone because of the custody agreement. He has had to keep the house phone. We've had to keep the house phone available for him to call the kids. Even if we don't answer all the calls, the phone would ring all day, one time after another, filling up from the answering machine. I tried to report this when he was in Marquette. I couldn't get through to the warden and no one returned my calls. I also tried to report this at the Parnell and had the same problem. No one returned my calls. I feel like his right to call the kids has been used to continue to stalk me from prison. I don't know how to put into words how this has made me feel. I feel hopeless and afraid. Some days I struggle to want to get up and to keep going. I don't feel safe from him at all. I didn't really stop this behavior until very recently. My children and I have not really had a chance yet to start healing because he is inserting himself into every part of our lives daily with phone calls. Judge Bergmeister told him a couple of times that I facing a possible life sentence, I would be quiet. Once these new charges were issued and the judge reinforced the no contact order, he started being more careful about calling. He still asks where I am and still sends letters. I don't see any change in his behavior. Anytime he gets irritated or on a call, he will threaten to take me to the court through the kids. He threatens to make sure my friends go away. He yells at the kids and at me. Then he calls right back to apologize because he doesn't want to be, he doesn't want me to be mad and ruin his chances of getting out. He will express remorse and promise to do better, take classes and say anything he has to in order to get out. But his actions don't change. It's like the rules don't apply to him. He just finds more clever ways around them. When I was told he was given a plea deal and expressed my fear, I was told, unfortunately, I would probably have to watch my back for the rest of my life. I would like to ask the court to consider his sentence be served consecutive because what he has done to me should not be taken lightly. I should not have to watch my back for the rest of my life. And I'm standing here today begging the court to please let me and my kids have somewhat normal life and to give our kids a chance to really heal and grow mentally, emotionally, and as people before he returns. I truly believe he'll do anything to get rid of any family, friends, or support I have in hopes that if I have no one, I'll have no choice but to go back. So once more, I'm gonna ask to please consider me and my kids in your decision-making in this case. On Monday, he called me and told me being a good mother means keeping us all in the same house. Like, I don't want to do this anymore. Thank you. Another question, please. Thank you. By the way.
Now, this is one of those cases that you think about and think to yourself how terrible it could have ended up. And while it was happening, we were dealing with CPS and trying to figure out how to get him back into jail, those type of things, because there was just a lot happening. Absolutely, he was stalking her. It took us a little while to get this on the docket because he had to be written by district court. So he's been in a little bit. He's 1 year into a 2-year sentence on the felonious assault that this court sentenced him to about a year ago. Despite that, I'm asking the court to do consecutive. I talked to Mr. Haven about that. He did write in his report that he recommended concurrent. Seems more like a Lansing directive than a request by Mr. Haven, but they have their own rules. The court has discretion to do consecutive. His guidelines are 12 to 24. I'm asking the court to max out his guidelines and do that consecutive. I don't have to add any more because I had a long speech, but I think Ms. Gray covered all of it. So I'd ask the court to sentence him accordingly. Thank you.
All right, thank you. Mr. Dermott,
Yes, Judge, Mr. Clum is 43 years of age. There was a custody agreement that the parties reached that was entered with this court in the family division. I think both parties were represented by counsel, and my understanding is that Mr. Clum is following whatever the agreement is in that court order. So the phone calls are not being made, at least that's my understanding, outside of what the order requires. There's some language in the order regarding psychological evaluations, counseling, contact with the children, those kinds of things. So I think Mr. Clum is doing all of those things. I think Mr. Clum, in his allocution, would indicate to the court that he is employed in prison. He hasn't been flopped. He hasn't had any new charges or any new tickets. He's completed a lot of classes. He's in the automotive mechanic program that he's going to graduate with. So Mr. Clum is doing things that are available to him in prison. And Mr. Clum just handed me, he's participating in a comprehensive psychiatric evaluation with some updates. I haven't read all of it, Judge, but at least it indicates from the Department of Corrections that he is at least engaged in those services in the prison system. The date of offense in this matter was over a year ago. It was, I believe, in December of 2023 into March of 2024. So over a year ago. The warrant that was issued in this matter was in August. And certainly the Crawford County Prosecutor's Office knew where Mr. Clum was. He didn't get arraigned until January of this year. And then suddenly pled, and we're here for sentencing in a short 3.5, 4 months time frame. Given the delay that the prosecutor's office has created, because they knew where he was, they could have authorized the warrant. The warrant was authorized in August of 2024, and they could have had him arraigned. They could have had charges brought in. This was a delay caused by them for about 5 months, 6 months for not, and they knew where he was. It's not like he was not being found or he was absconding. They knew where he was.
I need to interrupt. That's not true. We don't writ them for the initial arraignment. That's done by district court.
To me, it's completely irrelevant. So I don't care how long.
Well, I think it's important for the court to know why he was not arraigned until January, because Ms. Koch's argument is he should be sentenced consecutively. But had this been, when the warrant was authorized in August, he was in at that point about 6 months into a sentence. So he's here done a whole year in his prior sentence. And now Ms. Koch's argument is, well, there should be another consecutive. So again, there should be some delays, and the court should consider those. Again, the court has discretion to do what the court wants to do. But again, the court should have the time frame that this was not a delay caused by Mr. Clum. Mr. Clum was arraigned in January. He took full responsibility for his actions. That's what he says in his PSI. He pled at the district court level, and he's here for sentencing. So none of the delays were caused by Mr. Clum. Mr. Clum was aware at the time of the prior charge that these cases were being investigated. The report indicates that he did interview with Deputy Clepatlow regarding these new charges. So he had full knowledge. And again, we didn't know when they were coming. We don't get those notices till the arraignment, which was in January. But the warrant was authorized in August. So again, I don't think that consecutive, given the delay, which was not caused by Mr. Clum, is appropriate in this matter. So I would ask the court not to punish him for something he didn't do causing the delays. But if the court is going to impose a consecutive sentence, I would ask for a much shorter, lesser sentence so Mr. Clum can get out and take advantage of some employment and some other certifications that he's enrolled within prison, and then can get back with his life and start living his life. Thank you.
Thank you. Mr. Conlon, if you wanted to say.
Yeah, I actually have MCR rule 6.004 sub rule D for the 180-day rule exception. It states that at the time of which prosecutor knows that the person is charged with offense or is incarcerated in a state penitentiary. For purpose of this sub rule, a person is charged with a criminal offense if a warrant, complaint, or indictment has been issued against the person. Remedy is, if case is covered under sub rule 1, the defendant is entitled to have charges dismissed with prejudice if the prosecutor fails to make a good faith effort to bring the charges. She knew where I was at, and she spoke of the indictment coming and the charges, complaint, and everything at my last sentencing over a year ago. By this rule, these charges should be dismissed under the 6004 sub rule D, part A and.
Okay, we're here for sentencing today. There isn't a motion in front of me on that issue.
I actually have been trying to get him to do this
Okay.
since.
You may have been trying to do whatever you've been trying to do. It's not in front of me today. If you want to raise that as an issue, it have to be raised at a motion, set for hearing, and I'll address it in due course. I'm not going to discuss anything today based on.
I would like to set that in for a motion.
I'm sorry, what's
I would
that?
like to set that for a hearing and a motion.
Feel free.
Go ahead.
And then for the phone calls and stuff, like he said, we have a court agreement and getting in the phone lines in prison is very difficult. So when I get there, I have to call because it says I have to pay for the calls. I have to initiate the calls. Allowed 2 a day. And when I'm calling excessive times, the phones ain't being answered. I have recorded phone calls of the phones being turned off. My children are telling me this. Phone numbers being blocked. And up until a week ago, I'd be talking to the kids. Stephanie would take the phone from the kids and speak to me. She would have me call her while she's leaving work. And she has been talking to me, taking the phone for them and talking to me. My youngest daughter, I've only been allowed to talk to my son twice in a year because she hasn't been giving him the phone, and for him behaving better since I have left because of me. He has been kicked out of school for 30 days this year and is being so bad in school. The school has asked him to stop coming, to go to alternative ed at the age of 14. Grayling, he was doing much better when he was with me. He was actually passing the school. I know right now that he is not doing good in school and it's being blamed on me, and I'm not there doing anything with it. I'm not allowed to talk to him or nothing. So I don't know how I'm influencing his bad behavior. Also, I am, like you said, I'm enrolled in vocational village through the prison system, which I will come out a master certified auto and diesel mechanic. And I am entitled to a small business loan when I leave, if I still get out within 60 days of my current release date, which is March of next year, because if it gets extended, I'm no longer available. I'm taken out of the pool for it. It's only 3% of the prison population that can get these classes and qualify for this, and I am one of them. I've been doing good in there. I've not gotten in any trouble, taken all my classes, volunteered for extra classes, done my psych evaluation. I go twice a month to see the psychiatrist. I am on steady meds now, which I wasn't before, which really messed me up. I do take full responsibility in my part of this case for the GPS, but I'd like to state, I am not the one who put it on the vehicle. I had knowledge of it. I did not buy it. I did not activate it. I just had knowledge of it being there. Michelle Danko was the one in charge of running it, and she would send me information on it. I was not tracking it, did not have it on my phones. Even when the detective had my phones, it was not on there. I showed him everything on my phone to prove it was not on my phone, but I did have knowledge of it. I will admit that totally and fully.
Anything else that you wanted to say?
Oh, and for fines and costs, in prison, once we're sentenced, you guys send another thing in. And it takes my money from me alone, then I'll only be allowed 50 a month. I have to pay for phone calls to my children. I'd ask that the fines and costs be paid on parole so I can still make the court order phone calls through my custody agreement.
Okay, like the other issue that needs to be the subject.
Okay, I didn't know, that's why I'm asking now.
Yeah, you would need to file that, and I would consider that due process.
Okay. I believe that's it. It's just, oh, I have one question. Will my phones and be released from property after this? Because the county sheriff has them.
Ms. Cole?
I will contact the detective and ask him that question. I wasn't aware that that was an issue.
And then I wasn't either, Judge, and I'll coordinate that with Scope. Normally after the case is done, he's sentenced, that'll just get released to his property. The question is, I don't know who's gonna pick it up on his behalf.
Yeah, I
and
think
it's
you
gotta be
probably
released.
need to make.
Yeah, I'll make arrangement. I just,
To the sheriff's department, to get that. But I believe they typically release evidence once sentence is occurred, so. I don't have that. Okay. Turn to somebody on your. Okay, all right, thank you. So I did review the pre-sentence report in this case, so I'm familiar with the allegations here. I'm familiar with you, Mr. Clum, and your background based on prior case that you were in front of me on. So I've got a good history and background on you and the circumstances that bring you forward the court here today. Ms. Gray, I want to tell you I appreciate your statement. I did read your written statement prior to the hearing today. But has much different effect when somebody comes into court and speaks than it does on a printed page. And gives me a much better view of the effect that these crimes have had on you. So I appreciate you coming in. I know it's not an easy thing to do, and I know it's upsetting for you, but I think it's important that victims do that. I think it sets a good example for other people, in addition to being accountable to me in terms of fashioning an appropriate sentence. So I'm coming in.
I make more seconds.
One more and then it's fine.
Yep. I'm sorry. I meant to say, I apologize for ever making you feel this way and making our kids feel this way. I know I messed up. I was trying to get help for my psychological problems, which you asked me to do. I'm sorry that it's ever went to this, and I hope we can move on. You can be happy, and I get to see my kids again when I come home. And I'm sorry that you feel this way, and I am proud of you for standing here and making your statement today.
So one of the things that I have to do, Mr. Clum, in fashioning a sentence is it has to be a proportionate sentence. In other words, it has to take into account both the circumstances of the crime itself and your circumstances, your past behavior, and so forth. And in this case, I think those are both important factors to look at. You've got 8 prior felonies, 5 prior misdemeanors, many of those assaultive in nature, including sexual assaults. You've been to jail 9 times, you've been in prison 1 time, you've been on probation 5 times. You've got a lengthy history of engaging in this type of behavior, assaultive behavior. You certainly have a history of engaging in assaultive, harassing, what I would view as stalking, and just mentally torturing type of behavior towards Ms. Gray. Based on this case, based on the previous case that you were trying to get. And if I'm faced with a choice of who I believe in terms of what's really been going on here between you and Ms. Gray, based on your history, you don't have any credibility. I think you've been trying to find ways to minimize your behavior in the previous case, in this case, trying to find any way to distract from your actual role in the relationship and how your actions towards Ms. Gray and your family have affected them. And you can choose not to accept that or not, but I'm telling you, sitting here as an objective person, I find Ms. Gray's version of your actions much more convincing then your version.
I take full responsibility to it as for like.
So I didn't interrupt you. If you interrupt me again, I'm sorry, so I'm gonna have the officers remove you from the courtroom, and I'll just say what I'm gonna say. So please don't interrupt me again. I think the course of conduct directed at her has been deliberate. I think you have a deliberate scheme and plan in mind to try to control her, try to prevent her from moving on from her life. And I think you're using your children to do that. I'm totally convinced. Her version of these phone calls to me, given your past history and your actions, seem much more like what's really going on than your version. I'm just trying to talk to my kids. Don't believe that at all. And I don't think you should be able to, you do have the right to have parenting time with children, but you don't have the right to use that time to further harass, stalk, aggravate this. And I think that's exactly what you're using it for, because that's the only mechanism that we have available to you. And I'm convinced that anytime you have any mechanism available to you to try and get to her, you're going to use that. So I don't think you should have contact with your children. I'm going to make it part of the sentence that you not have any contact with them or her, because I think you're using that again as a way to get to her. I am going to put you in prison for as long as I possibly can, because I think the longest possible sentence is necessary to keep you away from her. Because I'm convinced that the minute you're released, you're going to again engage in this course of conduct. And so I think it's important to get you away from her for as long as I can possibly do that. So the court is going to sentence you to 24 months to 5 years in the Michigan Department of Corrections. The court is going to make that consecutive to Crawford County docket 245-291. The court is going to order that you not have any verbal, written, electronic, or physical contact with Stephanie Gray or the children that you share together, either directly or through another person. You must not be within 500 feet of her residence, school, or place of employment. The court is going to enforce a crime victim assessment of $130, court costs $325, attorney fees of $350, $68 state costs. You have the ability to seek an appeal of this sentence. Mr. Murphy, have you had Mr.
Yes, Judge, Mr. Clum has his appellate paperwork. He's acknowledged receipt of that appellate paperwork as well. Thank you.
Mr. Clum, you already minute is custody of the state at this time.
Can I make one more statement? All the
No.
phone calls.
I'm listening to you.
Okay. That's fine.
Will you file, yeah, will you file those motions for those stuff?
Sure. Why should we also go? Wilkerson's here. Wells is here. I haven't had a chance to talk to him.
What's that?
Mr. Wells is here.
Did you have a chance?
I haven't. Mr. Plum came in at the same time, but Ms. Wilkerson's here if you want to.
Let's move forward with Ms. Wilkerson's case and then we'll address. Record in People versus Wilkerson, file number 245351. The record should reflect Ms. Wilkerson's present here in the courtroom today.
Sierra Coke on behalf of the people.
Thank you. I'm ready for a
Wilkerson, have you had an opportunity to go through the pre-sentence report and talk to Mr. Murphy about that? Mr. Murphy, are there any additions, deletions, or corrections to the report?
No additions or corrections, just corrections by way of elocution that we'd like to argue some of the bond conditions and the length of probation.
Okay. Ms. Coe, do people have any additions, deletions, or corrections?
No, Your Honor. No, Your Honor.
Anything on behalf of the people for allocation? Or do you have any victims that wish to address the board?
He is not present.
Anything for allocation?
Your Honor, I think that this is the case, it's tailor-made for 76948. These people have had a tumultuous relationship. Mr. Gramuthi and I talked about this case a lot. The last thing that I wanted to do is try this case and have Ms. Wilkerson end up with a felony because she has 0 misdemeanors, she has 0 felonies, she's 36 years old. You know, she has gainful employment. I think that this is completely appropriate. I think she's gonna follow probation. I think she's hopefully gonna do well, and this is gonna come off of her record, and we're not gonna have to deal with her again. Frankly, when I charge these, I expect to try them. It's not very often that I don't want to try a case, and this is one of the ones I really did it. I do hope Ms. Wilkerson takes this seriously, uses her probation well, and that we don't see her again in this court. Thank you.
Thank you, Judge. Ms. Wilkerson is gainfully employed. She is the primary provider of the minor children in this matter. Her and a significant other are not together, but were living in the same home. Parent the children in the minor is at least save some money with housing and other things. There are two sides to the story, but I think the risk was if Ms. Wilkerson would be convicted, there'd be a felony or a would certainly affect employment and other things. And if she wasn't convicted, but that's the gamble and the risk that the defense had to deal with. I think Ms. Coke historically discussed this quite a bit, went back and forth, and we weighed those risks. And I think Ms. Coke was on the same level that if she's convicted, that felony would affect and have an adverse effect on Ms. Wilkerson, which nobody wanted, because the incident was, I think, just a bad incident that happened, but it was other things that led to it. In the past, Ms. Wilkerson has had a PPR against the victim in this matter. She, I think, was totally afraid of what happened and then reacted in that manner, but we just don't know what a jury would have done. And I think this ended up in a good resolution for Ms. Wilkerson. The report indicates that she should be on the term of 1 year probation, but it says that she can be released early, but the rehabilitative goals and so on. So I just want some clarification of the court. If the court's going to put her on probation for a year, she's already been on bond conditions for 6 months. I would just ask to lower that to 6 months of probation. Ms. Wilkerson has done just fine on bond. She doesn't drink, she doesn't do any drugs. I think there's some points here regarding some substance use, but she doesn't do any of that. And the incident, she was not drinking, she was not under any controlled substance, she was not intoxicated. So I don't think that's necessary either. And I'm just trying to save any fees that Ms. Wilkerson will again have to submit for testing or other things. She's done that while on bond, and she's been on compliance with bond conditions as well. I don't think we're going to see Ms. Wilkerson back here. She's a very nice person to deal with, but I think she has some underlying triggers because of the relationship dynamics. She has to deal with those. She understands that, and I would ask you to follow the recommendation with those modifications that we've asked the court to make. Thank you, Judge.
Thank you, Ms. Wilkerson. Anything you want to say? All right, I did review the report, so I'm familiar with circumstances here, as well as your personal circumstances and background. Looking at all of those factors, I do think that term of probation with no upfront jail is an appropriate resolution to this matter. I also think that probation pursuant to 769-4A, which would allow you to have this come off your public record, is also appropriate given all the circumstances. I am going to follow the recommendation. You will be entitled to be released early from probation. I expect that that's probably going to be the case. So I am going to impose the recommended term. But again, as indicated, if you're compliant with probation and making progress on payment of fines and costs and so forth, there's no reason why you shouldn't be released on probation early in this case. So the board is going to place you on probation for a period of 1 year, subject to all the terms and conditions in the report. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state cost.
Just could we ask that the court waive the attorney fees in this matter, the $350? She is employed, but I would like to have
Yeah,
this.
I'll waive the attorney fees.
Thank you, Judge. Anyone with further allegation? Thank you.
The other question I had. I know Ms. Wilkerson has a previous conviction that was expunged, but she was arrested, as we know, that prior to the order that.
Judge, I'm
It was
not
a long
sure.
time ago. I don't know if it's mandatory back.
Usually I look in the lien.
She was
I
not.
do not recall
Okay,
doing that in the past.
okay, so the court will order the DNA testing $60 for that. And then supervision fee of $30 per month while you're on probation. Because this is pursuant to 769, right, there are no appellate rights at this time.
No, thank you.
No, sir, thank you.
Do you need Ms. Wilkerson to check in with you?
Yes, I'm gonna meet with her in the lobby.
Check in with Mr. McDowell before you leave.
I'm gonna meet Mr. Wells and, Mr. Hill, and I'll be right back.
Okay, we'll take a short recess and back on track. Are you ready on Mr. Wells' file?
I am, yes. Mr. Wilson.
People versus Wells, file number 245359, refugee collections courtroom today. Council, put your hands on.
Sierra Coke can be after people.
Thank you, Reverend Mr. Wells.
This is set for final status conference today. We do have trial set to begin on Monday, the 14th. So this is the plea trial date. Mr. Murphy, how does Mr. Wells?
Judge, I discussed the plea with Mr. Wells. I wanted to have the last conversation with Mr. Wells today. The plea has been the same all along. It's attempted, one count of an attempt, CSC second. Mr. Wells understands the risks and the charges and the guidelines, and the difference in the guidelines. He's rejected that offer, and we would ask that we go to trial Monday.
Okay. Mr. Wells, is that accurate?
Yes.
Okay, so again, Ms. Coke, the court will give that case priority then. We'll adjourn this advanced trial to a later date. I believe this is set for 2 days, is that right?
Correct. We might be able to do it in a day, but given picking a jury, that could be an issue. So I would still ask for a 2-day trial.
Okay. And Ms. Coke, again, the court will sign that order for access to the jury questionnaires. Submitted your proposed jury instructions. I believe you did.
Yes.
And I submitted my request for jury questionnaires as well, Judge. So
Okay,
I don't know if you received it yet. Those were submitted early this week.
I think I did sign.
You did.
those, yeah.
All right, thank you.
And then, Mr. Gamerthy, did you have any additional or different jury instructions?
No.
Okay. All right, so Mr. Wells, you'll need to be here by 8:30 at the latest on Monday morning.
That's it.
Along with council, and as soon as we have everybody assembled, we begin with jury selection immediately. Ms. Coke, anything else that we need to address in this file prior to that date?
No.
Mr. Gamerthy?
No, sir.
Thank you, that's all.
Mr. Welch, room that I showed you, wait for me in there. Okay. I see that little room there.
Your Honor, do you want me to just text Mr. Truce?
I'll let Mr. Truce know. Ms. DeFan, you're free to go. We are gonna adjourn your trial, but make sure that you stay in touch with Mr. Truce because we'll be resetting it for a different date, okay? Yes. For the record, in People versus Mallory DeFan, file number 245348, the court has released Ms. DeFan to leave the courthouse in light of Mr. Wells' case, which will have precedence. We're going to proceed with that trial on Monday. We'll reschedule Ms. DeFan's trial and the court will notify Mr. Truce, given that he is also on the record. Are you ready on Mr. Hill's file?
I am, Judge. Just, so Mr. Hill's file, there's two set for today. There's a probation violation that's set out 30 days from now. If we can have Brooklyn just pull the probation violation file as well.
I had it added.
You have it?
I had it added.
You did? Okay, thank you. I
Just
did.
as a correction, I have that as set for June 5th.
That's what I have as well. But it was added for today?
I asked Jen to add it. I see it on my docket, the probation file, just in case there was a plea.
It is
Okay.
on, it is on for today as well, but I do note that to the extent it's not resolved today, we do have it set for hearing.
Perfect. It's going to get resolved today. So I appreciate adding that to the docket. But
Okay, Mr. Hill, yeah, forward. And for the record, this is file 245287. File 255386. To the record, reflect that Mr. Wells is present for the report today.
Mr. Hill.
I'm sorry, Mr. Hill. Mr. Rock, please speak for there. Mr. Germer, how did we want to proceed, Mr. Wells, please?
Judge, in file number 5386 FH, Mr. Hill would be pleading to property on the constituted third offense. And the other file, Mr. Hill would be pleading to one count of police officer resist and obstruct and domestic violence second offense.
That is correct.
I'm sorry?
That is correct.
And the remaining charges and habitual offender notices would be dismissed. And that would then certainly give the court enough preponderance in the probation violation file to take the plea of guilt as well.
So As charged by 386.
Correct.
OWI, okay. Ms. Coker, is that a correct statement of the plea offers in this case?
Yes, just so the court's clear, he's pleading as charged to the OWI third, but we're dismissing the habitual third offender notice.
Mr. Hill, have you had an adequate opportunity to speak with Mr. Gerber about these plea agreements? Yes, sir. Is that how you wanted to proceed today? Yes, sir. You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Thank you. You can lower your hand. Ms. Coke, I have a crystal against the Zoom meeting room that,
That would be the, I believe in this way. This was
She's
not,
on the docket at,
not for this case, Judge, she's.
oh, different cases. I just wanted to make sure what it's like that. For this one.
No, not for this one.
All right, so Mr. Hill, I'm gonna go through a few things with you here as we get started with this plea hearing. First of all, I want to make sure that you understand the maximum possible penalties on the new charges. For operating while intoxicated as a third offense, the maximum possible penalty phase would be up to 5 years and or $5,000 fine. Do you understand that? Yes. For the charge of assaulting or resisting a police officer, the maximum possible penalty is up to 2 years and or a $2,000 fine. Do you understand that? Yes. And the charge of domestic violence, second offense, maximum possible penalty on that charge is up to 1 year and or a $1,000 fine. Do you understand that? Yes. And then you're also going to be pleading guilty to violating your probation. That would subject you to the maximum possible penalty on your underlying charge in that case, which is possession of a controlled substance. That's 2 years and or a $2,000 fine. Do you understand that? Mr. Germerty, is there any potential for mandatory or discretionary consecutive sentencing?
There would be discretionary sentencing, Judge. Mr. Hill was first charged with the operating while intoxicated third while on bond, then was arrested for the RNO and the domestic violence for second offense charge.
Okay, so Mr. Hill, because you were on bond at the time of the second offense, the court has the option, but is not required to sentence you consecutively. That means back to back as opposed to serving the sentences at the same time. Do you understand that? Yes. With all of those things in mind, what is your plea to those charges today? So right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you during a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial, to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights? Yes. You understand that you're giving up and waiving all of those rights by pleading guilty. Also, any appeal that you would have of your plea today would be by leave to the Court of Appeals. That means you don't have an automatic right to appeal it. You would have to ask for that court to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. I understand that. Has anyone threatened you with anything to get you to plead guilty? No. Has anyone promised you anything other than what we said here in court today to get you to plead guilty to any of these charges? Sure. Is it your own free choice to enter this plea? Yes. Are you pleading guilty to these charges because you are in fact guilty? Yes. So the first incident is the operating while intoxicated. The information I have indicates that happened back on February 5th of this year. Is that the correct date? Yes. On that date, had you been consuming alcohol? Yes, sir. After consuming alcohol, did you operate a vehicle on County Road 612 here in Crawford County? Yes, sir. And At the time that you were operating that vehicle, were you intoxicated by the alcohol?
Yes,
Do you know what were there any tests done to determine the level of alcoholic blood, correct?
blood test,
Do you remember what the result was?
I believe that was 0.21.
Do you have any reason to doubt the accuracy of that test?
No, sir.
Did you consume enough alcohol that you think your blood alcohol level could have been that high?
Yes,
Had you previously been convicted of operating while intoxicated back in 2017? Second district court in Oakland,
sir.
and all the way back in 2004 here in Crawford.
Yes,
The other case happened on February 12th, 2025. Does that sound the right date?
yes,
Have an altercation with Eric here.
yes.
Is that a person that you had a dating relationship with?
I was there for almost 12 years.
Okay. And is that a physical altercation?
She said that I had pushed her. I never laid a hand on her until that day. Of course, my alcohol had something to do with it. I do feel like as we proceed, I would like to do some kind of treatment.
So, did you push or shove her at that time?
I believe so, yes.
And did that occur at a location here in Crawford County?
Yes, sir.
Had you previously been convicted, again, going all the way back to 2004 of domestic violence charge?
It's been so long ago, I think it's on my record, I guess so.
Do you have any reason to doubt your criminal history of shows that you were convicted? of
No,
domestic
sir.
violence? Did you, on that same date, encounter a deputy from Crawford County?
Yes,
Was he responding to the domestic situation?
yes.
Was he wearing his uniform?
Not that I could see until I got arrested, but yeah,
Did you know he was there acting as a police?
yes, sir.
Did he give you some commands or order you to do something that you failed to do?
Yes, sir.
And again, those commands were given as part of his investigation or response into the domestic incident.
Yes,
And at that time, at these events, you were on probation here in Crawford County, is that correct?
yes, sir.
Were you aware that one of the conditions of your probation was that you were not violating laws of the state of Michigan?
Yes, sir.
Ms. Coe, are the people satisfied with the factual basis?
Yes, Your Honor.
Yes, sir.
Are the people satisfied, or I'm sorry, are the people aware of any threats, promises, or arrangements other than what's placed on the record?
No.
The defense is not either.
Ms. Coe, are the people satisfied that the court has complied with statute and foregoing taking of this plea?
Yes, Your Honor.
I would agree.
Mr. Hill, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's an actual basis to support a finding that you are guilty of each of these charges, as well as the probation violation. Court will accept your guilty plea as to all of them. We'll set this matter for a sentencing hearing. Prior to that hearing, we'll speak with the.
No.
I would just like to argue a bond modification, Judge. Mr. Hill has resolved all three of his files at this point. Certainly the guidelines are we call for a jail sanction, I believe, at this time. So I know Mr. Hill, some of the incidents that led to this was the death of his daughter. I think that's why he was doing well on probation and then just picked up a slew of charges because of that death of his daughter. So I would ask that the court modify his bond so he's able to at least post bond. We'd revoked his bond previously, get some credit. I think Mr. Hill wants to get some treatment, take care of some mental health issues that he has, so he can then work towards being on probation and complying back with probation. He's also asking the no contact order be modified with a significant other, so you can start communicating with him, so we can begin healing family.
I'm sorry, Ms. Cole.
And I don't have any objection to the no contact being lifted. If the victim wants to have contact with them, I mean, he's lodged, so the damage that he could do is very minimal. He doesn't, his criminal history for the court, he has a 1997 felony breaking and entering into a vehicle to steal. He's got a 2001 delivery of less than 50 grams. He has a 2005, some type of ordinance violation. It doesn't say what, but it started as a liquor violation of some sort. We have a 2003, no insurance, operating while intoxicated. We have a 2017 operating while intoxicated. We have a 2020 ordinance violation permitting another to violate the vehicle code. Sure, it's kind of a strange one. We have a couple of things that do not have judicial segments from 2020, and we have 2004 domestic violence deferred. I think based on his criminal history, I mean, he's going to get some time with an OWI third. I'd ask the court to not modify the bond to allow him out today, and then we can address that at sentencing once we see the guidelines and where he's at. He hasn't been lodged for that long. This case has moved pretty quickly. So I think it's better to wait until sentencing. Thank you.
So in terms of bond, Mr. Hill, once somebody enters the plea, is convicted, they're no longer entitled to bond. I think in the circumstances here, you're getting credit for the time that you're in. I do believe based on your convictions and prior history, the sentence is going to exceed the time that you would have served between now and sentencing. So I'm not going to modify the amount of bond. I will lift the no contact provision. There's no objection to that. Incorporates Mr. Gerber, fair stipulation order, modifying
The no contact. We can do that, Judge.
and that the court will set this sentencing.
Question, I know last time I was in court, because she put a PPO on me. I think that should be set for today too, on the Zoom. I think that's why I,
docket for today, it may be set, just might not be.
okay, that's why I was asking for no contact.
He still can't.
Be lifted.
She moved it, and he will. But there's no contact for that case.
It's not set for today. If you file that motion, that should be.
Okay, well, I had seen you the last time we were in court, and then I got adjourned for 30 days. And I had asked the court to adjourn that as well.
Okay.
So I was kind of under the assumption that it would get adjourned for the 30 days too, and be on the same date as this.
Right.
I haven't received any paperwork or anything, and my attorney wasn't present. It was just me, you, and Erica Gearing.
I'm not on the PPO file, Judge, so I will not get notice.
Yeah, I think. I remember, correct me if I'm not remembering it right, but I think the issue was Mr. Hill making a statement
Correct.
testifying with these criminal charges pending in the
Correct.
PPO matter. I think that's why we moved that. So that's now resolved, with this being resolved. I can have. You can look and find out when that date is.
Okay.
I can, through the courthouse.
Okay, thank you, Your Honor.
And Your Honor, I just want to make it clear so Mr. Hill doesn't have any issues in understanding this. There's still no contact in the PPO, but they're
Yes.
controlling that. So once that's resolved, I just don't want to think, oh, they said we can in this case. Well, we didn't object.
Yeah.
It's being dealt with civilly, so.
Both of those.
Yeah.
Will be lifted.
Yep.
Okay.
That's why I wanted no
Yep.
contact lifted, and then I thought the court case for the PPO was today too. Hopefully get both of them lifted and at least have contact with my son and
Yeah.
go from there.
Is this greening here? So we'll check on that, but yeah, you're definitely picking on the right track here, so, okay.
I'm trying, Your Honor.
Understand, okay.
All right,
Thank you, Mr.
thank you.
Say,
People versus James Douglas, file number 1944502250028.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, James Douglas, present here with us in the courtroom today. Mr. Douglas is here on a probation violation. He intends to admit the alleged violation, which was not reported to his agent, I believe it was June 6th of last year. That's Mr. McFaller's case that supervises.
Okay, he's going to admit to which count, sorry.
Failure to
Technical.
No, I believe
Those move past the
because
time
of the
frame.
length of time since that was filed, it's become non-technical. That's how it is.
Gotcha. Okay. So, Mr. Douglas, have you had a chance to speak with Mr. Thompson about?
Yes.
Is that how you want to proceed?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Douglas, you understand, number one, that you have the right to have a hearing as to whether or not you did violate your probation?
Yeah.
You understand that by pleading guilty, you're going to be giving up that right? So you say yes?
Yes.
And then by pleading guilty to the probation violation, it could subject you to the maximum possible penalty on your underlying charge, which would be up to 1 year in jail. Do you understand that?
I understand.
In light of those things, what is your plea to the violation?
I literally saw I missed my supervised date, and if I am guilty of that.
Okay. Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything?
No.
No free choice?
Yes.
And you're pleading guilty, you indicated that you did violate probation?
Yes.
Back on or about June of 2024, so 10 months or so ago, were you on probation here in Crawford County?
Yes.
And were you aware that one of the conditions of your probation was that you were to report to your agent as directed?
Yes.
And you indicated that you don't do that.
Yes.
Court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea. Mr. McDowell, how did we want to proceed in terms of these things?
Judge, I just asked to be set for sentencing. I'll prepare a short PV report.
Okay, so we'll set this for sentencing at the court's next available date.
Yeah, if the court was inclined, Mr. Douglas would waive the PSI and has to be sentenced.
I don't have an issue with that, Judge. I wasn't necessarily prepared. I don't have jail credit days lined up or anything like that. But if with the guilty plea, I mean, if he's prepared for sentencing, there's some mitigating factors to this violation, Judge. Mr. Douglas has been kind of homeless off and on during the course of this time. I would just, if I was gonna make a recommendation today, I would just be recommending an additional 15 days jail from today's date and discharge from probation on his files.
Thank you, Your Honor. This is a case where Mr. Douglas got very close to completing his probation. This was actually his last one as probation officer. He took a job, a traveling job. It was with a carnival that travels. He dropped the ball on me as probation officer. Catch up and pay all his fines and costs, which was very difficult for him. Mr. Douglas is someone who really struggles financially. He doesn't have family supports. He, has the record he has now, and it took him a lot of effort and a lot of work to pay those up, but he did. And he wants the court to understand that he prioritized his court payments and he made those. He understands he failed to report and he didn't turn himself in a timely manner. So he is prepared to accept responsibility and to serve a sentence for that. But this is an individual who did make some strong efforts on his probation, again, notwithstanding that he failed to report and that took objectively too long to turn himself in.
Sir, anything that you wanted to say?
This case has been going on since 2019. I tried my best to
everything for my children, and this is it. I just want to be done.
So just reviewing the file here, I don't familiarize myself with your case because it has been a while. I do think that the recommendation is appropriate. It looks like you were arrested back in March 26th, so that's what you got here at Crawford County. So if the court imposes an additional 15 days, we're looking at about 30 days in jail. The court has an interest in terms of the deterrent effect. When somebody doesn't report and it goes on for as long as years did, in imposing some degree of punishment for that, so that both you and other people see that you not follow your probation, that punishment including jail time is part of how the court deals with that. So I think that's a reasonable sentence. I think it accounts for your violations here, but I also think it recognizes this. Mr. Thompson said that he did make some valid efforts during time on probation. So the court is going to follow that recommendation and sentence you to 30 days in the Crawford County, 15 additional days in the Crawford County Jail. You do have credit from the date that you were arrested or brought here on March 26th. The court will discharge you from your probation. And I know you probably don't have it in front of you, but if you can just confirm that the fines and costs have been paid to the clerk so she can prepare that.
Yeah, I'm 90, I will. I'm pretty sure that I did that already, but I will confirm that.
Okay.
Yeah, and that's, I neglected to tell Mr. McFall of that, so that's why we're at where we're at. Thank you.
And then we'll need to prepare some appellate rights because we have the ability to appeal the sentence, Mr. Douglas. So we'll have those appellate rights prepared for you and get those to you at the jail. Okay. Anything further, Mr. Thompson?
No.
Thank you. That's all for today. People versus Bradley, case number 245301.
Your call can be after
Jason
people.
Thompson. I'm sorry.
Your call can be after people.
Thank you, Your Honor. Jason Thompson, Jason Thompson on behalf of the defendant, Alexis Bradley. Your Honor, we did receive the competency report. I don't have any different evidence to offer and understand that the court is going to find Ms. Bradley competent. I guess I would ask the court, just in terms of paper and record, the court still has the proposed plea sheet and proposed police report before the plea. It would be our intent to still enter that same plea we were discussing in December.
First of all, with regard to the competency report, Ms. Cope, did you receive and have a chance to review that?
I did.
Do you have any objection to the court finding based on that report that Ms. Bradley is competent and attaching that report as an exhibit to the court file?
No.
Similarly, Mr. Thompson, I think I know the answer to this question, but I want to make sure we make a clear record. Did you review that report?
Yes.
Do you have any objection to the court finding that Ms. Bradley is competent based on the information that?
No objection.
Objection to the court submitting that as an exhibit to the file?
No objection.
Now, in terms of the plea, is this going to be a no contest plea?
Yes.
Or
I'm sorry, I didn't hear you. You said you did or you didn't?
I do.
Okay.
I recall reviewing that previously. Don't see the plea sheet in here, so can you just state the terms of the plea?
Yeah, it's add account to accosting for immoral purposes, 750.145A-A. Truthful testimony against the co-defendant and HYTA. We have added, Mr. Thompson has a signed copy he can provide to the court.
Can you just initial that?
No.
And I can show you a text.
And what's this maximum possible penalty for that?
That's a 4-year, Your Honor. Yes.
250-145. A-A.
If I could approach, I do have another sign.
All right, Ms. Bradley, have you had a chance to talk to Mr. Thompson about this plea agreement?
Yes.
Need any more time to do that, or did you want to move to that plea agreement?
I'm ready to take the plea.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Lower your hand. For the record, again, Ms. Cope, what is the reason for
She has been struggling, and I think there is some civil liability issues too. I think there's some pending litigation.
There is potential civil liability. There's a pending NA case. Yes.
Oh, thank you. Ms. Bradley, you understand that by pleading no contest to the charge in this case, that the maximum possible penalty that you could face would be up to 4 years.
Yes.
Are you on any kind of other probation or parole at this time?
No.
With that in mind, what is your plea to that charge today?
No contest.
I'm going to go through your rights with you, okay? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights and you won't have those anymore.
Yes.
Okay. Do you have any questions about that? Also, if you wanted to appeal the plea that you're making here today or get it reversed or undone, you would have to ask the next court higher up, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal, and you wouldn't be able to get it reversed. You understand that?
Yes.
Do you have any questions about that?
No.
Has anyone threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
I've marked as court exhibit number 2 in this case, Michigan State Police Report, incident number 33-2103-23. Have you reviewed court exhibit 2?
Yes.
You believe that it would provide a factual basis for finding of guilt as to the kind of charge in this case?
Yes.
Mr. Thompson, have you reviewed that report?
Yes.
Do you agree that it would provide a factual basis?
Yes.
Ms. Hogue, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Thompson, are you?
No.
Ms. Hogue, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Thompson?
Yes.
Ms. Bradley, the court finds that your plea is knowing and voluntary or to satisfy based on the information in Court Exhibit 2. There is a sufficient factual basis to support a finding that you are guilty of this added count. The court will accept your no contest plea. Set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney, Mr. Thompson, okay?
Okay.
Before you leave today, you're gonna meet with Mr. McDowell to set up the time for a free sentencing. That's all we have for today. Thank you. People versus Natalie Bublitz, case number 255393.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Natalie Bublitz.
The record should reflect, present here in court today. How did we want to proceed?
Your Honor, I was asking for a adjournment of the status conference, or adjournment and another status conference. I was asking also asking the court to review and address bond today. There's a no contact provision with Ms. Bublitz's young child, and we would ask that supervised visitation be allowed.
As to the adjournment, Ms. Coke, any objection?
No, Your Honor, but the plea will be withdrawn at the next hearing.
So just so council's aware, I don't have date at the time of mandatory judicial conference beginning of May, so the date is going to be middle of May or June, just so both council are aware for the adjournment. But I will set it for the court's next available date for a plea hearing status conference. In terms of the bond request.
Your Honor, I frankly don't have any additional information because I'm not involved with any type of child protective services. And a lot of times they'll call me and tell me what's happening. I don't really know. There was a minor child in the car. The allegations are that Ms. Bublitz had the methamphetamine inside the child's onesie.
So are you?
Like I said, I don't have any additional information besides that. I mean, I think maybe supervised visits, if there's a CPS case open, would be appropriate. But I don't think we should have any unsupervised visitation given the allegations.
And that is our request, Your Honor, is supervised visitation. There is CPS involved with the family right now. There's not an NA case, but there's a CPS investigation. The allegation is that Ms. Bublitz had essentially hid some methamphetamine that was in a container inside her child's onesie, which is very serious. And she understands that at the same time, this is a young child would benefit from some contact with her mother. And I believe the supervised visitation would address the court's concern for public safety.
Okay, sounds like we have agreement here. I think Mr.
I can prepare a stipulated order to that effect.
Yeah. I don't have objection. Thank you, John. And then we'll proceed. Ms. Bublitz, just make sure that you stay in touch with Mr. Thompson prior to that.
Thank you.
Thank you.
Ready on this? We ready on Mr. Letts?
Yes, Your Honor. Yeah.
You want to come forward? The court will call people versus Devin Letson.
Excuse
me. File number 255389. Again, counsel, put your pencils out of the record.
Sierra Coke on behalf of the people.
Morning, Your Honor. Tyler Velo, P number 75702 on behalf of Devin Letson.
Thank you. This is set for status scheduling conference today. This is Mr. Letson's first appearance before Circuit Court at Plea. Can you tell me the status?
Yes, Your Honor. We're currently working on the case, interviewing witnesses. We'd ask for a little bit more time so that we can complete our investigation. I was thinking maybe 6 weeks for another pretrial settlement conference that we can come back and schedule trial at that time.
Your Honor, the plea offer in this case is domestic violence, first offense, dismiss the felony case. At the next hearing, the plea offer will be pulled. No objection to the adjournment.
So I'm going to set this matter for the court's June motion day, which is a little bit beyond, but I think you heard me this say back at the May date. So or we'll set it for a plea hearing status conference at that time. So Mr. Letson, between now and then, just make sure that you discuss any plea offers with Mr. Velo and be ready with the decision. When we're back on that. Okay. Mr. Velo, anything else I can address for your side?
Nothing further for the defense. Thank you, Your Honor.
Let's go.
No, thank you.
Thank you.
Thank you, Your Honor. Have a good day.
That concludes our morning docket. The court will be in recess until 1:30. Okay, this is the jail. This is Mr. Jones. That's his name. Thank you.